Good morning, everyone, and welcome to another session of the Parkway Speaker Series. Our guest today is someone who's been with us before, Judge Tom Frawley, retired from the circuit bench in the city of St. Louis. Tom spoke last time, and it was well received, about the anatomy of a trial. Today, and in a succeeding session, probably scheduled in April, he's going to talk about the juvenile court and his experience. I've got to tell you that I would guess that 95% of all lawyers do not have a clue about what goes on in the juvenile court. And probably the citizens even at a higher rate than that. So this is a great opportunity for a civics lesson and to benefit from the wisdom and experience of a great jurist, and I mean that sincerely. First, a quick story, because my mantra is always tell a story. 50 years ago, in the summer of 1971, there was a law student who drove a truck for Nabisco delivering cookies and snacks throughout the city of St. Louis. Many of the stores were small and didn't have credit, and they had to pay in cash. So instead of the sign saying on the side of the Nabisco truck, "This driver carries no cash," actually, this law student driver carried a lot of cash. $300 to $500 in cash, which is a lot of money. And lo and behold, I was held up twice, armed robberies in both instances. My mom made me quit the job after that happened. But one of them was a juvenile. I went to juvenile court after he was apprehended, the assailant, and I identified him and did whatever I had to do. The memory's a little faint, but I do recall that the juvenile judge basically said, "Young man, you're not from St. Louis. I understand you're from Detroit. Get out of town and never come back." And I was, of course, clueless about how or why that was the right result. And so today I'm still clueless about what happened in juvenile court. So maybe Tom can explain that one, or excuse me, Judge Frawley. Anyway, it's good to have you with us, Tom, and we appreciate your time and the wisdom and common sense that you'll no doubt impart to us.
Richard, happy to be here. The other thing, if you folks don't recall, or maybe I didn't mention it, I had the pleasure of living with Richard during our last year of law school, which was 71 through 72. So 85% of what I know is probably the product of having lived with him.
I think that's good, and I'll take it as a compliment.
I think it is good, and it is a compliment.
Let's start with the big picture about juvenile courts. Tell us what the law in Missouri endeavors to do. What's the job of the juvenile courts in the state of Missouri?
Well, the juvenile court really is divided into two pieces. One is what I would call care and protection, and the other is what I would call delinquency/status. Care and protection is designed to take children who are abused or neglected by their biological parents and remove them, if need be, from the situation, if not removed, to at least put in services to allow the family to better function and the child or children to be safe. I would say in today's world, the primary child that the juvenile court's confronted with in this setting is the child that's born drug exposed. The other side of the juvenile court is, as I said, delinquency and status. Delinquency is a basic criminal. A young man, as Richard described, who robs the Nabisco driver would have committed an armed robbery, perhaps other related crimes to it. But because he's under the age of 17, it would be referred to juvenile court. What is called a status offense are those offenses by children under the age of 17 whose act is subject to court involvement only because they are under the age of 17. Example, truancy. Example, behavior injurious, meaning they behaved in such a way in their home or in school or in the community that their behavior is potentially injurious to themselves or to others. That's the basic division.
And so as I understand it, we're going to talk about mostly in this session delinquency and status matters that came before you. And then in our second session, which will probably be later in the spring, we'll talk about the other side of it where the juvenile court is trying to protect the juvenile who's a victim of something bad.
That's fine with me, however you want to break it up.
I appreciate
You're in
that.
charge. When we live together, you're still in charge.
Yeah, right. In any event, let's start with the delinquency status offense. Is the purpose of the juvenile court to punish people like it is for adults who commit crime?
No. The theory behind juvenile is what I'll call rehabilitation, to find out what it is that drove the young man or the young woman to do whatever he or she did, and to try and address those issues, whether it's family issues, drug issues, gang issues, whatever it is. So punishment is not the primary focus. In fact, it's really long down the list of goals. Just as the whole juvenile process, from my perspective, on the delinquency side, is restorative justice. It's both on the victim side and on the juvenile side.
Now, when a juvenile is charged with an offense, what sort of protections do they have under the Constitution?
The same as an adult, Richard. They have the right against self-incrimination. They have the right to appointment of attorney if they can't afford one. They have the right to what we use in the legal, in the adult side, is called bail, and they have the right to be put out on their own recognizance or under a parent's signature, so that they're back in the community. They have what we call the due process rights that adults have. They have all the same due process rights. They have a right to a trial. It's not by jury, it's a judge trial. But the right to confront witnesses, meaning the witnesses have to come in and testify live. Their lawyer has the right to cross-examine them. The other part of juvenile court that's on the delinquency side is they have also what's called an informal adjustment, meaning there may be a situation where a young man or young woman is charged or allegedly committed an offense, but because of the nature of it, in terms of its gravity or lack thereof, it's deemed more efficient and perhaps more productive if they bring the family in and do what they call, as I said, an informal adjustment, where they meet with the family and the child and try and figure out how to stop this behavior. Maybe it comes down that the child is stealing from school, maybe doing things which are criminal indeed, and but yet are dealt with more in a way that isn't in the formal system.
I forgot to ask you this, but when I was handling the occasional divorce or dissolution of marriage case and there was a child custody issue, the courts always talked about the best interest of the child. Is that a guiding principle in the juvenile code?
On the care and protection side, yes. On the delinquency side, no. It's really, if rehabilitation versus punishment is the goal, arguably best interest of the child is
Somewhere
one of the components, but it's certainly not the one that's advertised as it is in the care and protection side.
So when you, as a juvenile judge, are trying a case, what's the burden of proof, and who's the individual who has that burden of proof, such as a prosecutor in a felony case in circuit court?
Every juvenile office, until recently, not the juvenile officer, who didn't have to be a lawyer, was his or her own prosecutor. And so you would have a layperson as a juvenile officer who would be presenting and doing the work of a prosecutor. The Supreme Court, I think correctly, has said no, every prosecutor has to have a lawyer when they present a delinquency case. Most often, certainly outstate, the lawyer for the juvenile officer in the delinquency side is one of the assistant prosecutors in the county. In the St. Louis City, St. Louis County, and I suspect Jackson County, and maybe others, but the city, which I'm obviously most familiar with, the juvenile officer has her own attorney and a staff of attorneys. So that attorney, a prosecutor, puts on the evidence, has to call witnesses, just as it would be in a criminal case. The burden of proof in a delinquency as opposed to status is beyond a reasonable doubt. And the burden of proof on the status offenses is lesser clear, cogent, and convincing, or preponderance. It's one of those two, but it's really it's less than beyond a reasonable doubt.
Did you ever find someone, I don't know what the right term is, not guilty in a criminal or in a delinquency status case that you're describing?
Delinquency and status are two separate tracks. Yeah, I mean, I did. If the evidence didn't support it, I found him not guilty.
And do you call it not guilty or guilty, Tom? Is that the ultimate term for it?
Well, the hearing is called an adjudication. So I've either adjudicated that he or she committed, or adjudicated he or she did not. So to me, it's guilt versus not guilty. Remembering it's not innocent. Maybe the state just, or in this case the juvenile officer, didn't prove the case, which doesn't mean the young man or young woman didn't do it. They just didn't prove it. Meaning they couldn't get a witness, or the witness wasn't as credible as he or she needed to be.
So it's a bench trial.
It's a bench trial.
Same rules of evidence?
Same rules of evidence, hearsay, relevance, yeah, all the same rules.
Now, who represents the accused under those circumstances?
I would say 95% the public defender's office. The public defender, I was in juvenile court from 2000 to 2005 in the city. Now, to me, that doesn't seem that long ago until I actually sit down and look at a calendar and I realize that it's over 20 years ago that I started, and 15 years ago that I left. During that term, the public defender statewide made I will say, concerted effort to ensure that all of the young men and young women that came through the city juvenile particularly, and maybe others statewide, had some form of representation. In fact, they had a lawyer, one or two lawyers assigned to the juvenile court. St. Louis County did too. And it was a difficult task because if you're the only person, and that's all we had was a really good lawyer. But she got all of them. And we had three judges, I think, at the time. And so you had to juggle being in three places.
So if a person is adjudicated guilty, does that juvenile have the right to appeal?
Yes, I have the same right. Obviously, after the adjudication, you go to what would the adult side would be called the sentencing. And there's multiple things you can do. Not as many as in the adult system. And I would say most of the kids that I had, ignoring the children that committed murders or rapes or robberies, which may or may not have gotten what we call certified to adult court, they got some form of probation. Alternatively, they would go to Division of Youth Services, which is ranges from basically living at home under the supervision of a probation officer to going to Hogan Street, which is the most secure detention facility in the state, which is housed in the city of St. Louis. And it's dorm-like. I mean, it's fenced, so it's not, you don't come and go, but they're living in dorm rooms with bunk beds, and they've got a gym, and it's kind of like, it's an old school. In fact, it's an old school building. So to get back to your question, I don't know, I don't remember being appealed, but you certainly have the right to appeal. But since most of these I'll say lower end, not to diminish the significance to the victim, crimes, they got put in some form of probation, which is not appealable because it's not a final judgment.
And then the worst that could happen is they'd go to the facility you just described in the city of St. Louis.
In Hogan Street.
Hogan Street.
Now, what's interesting about Division of Services, and they are nationally recognized as a model of how to handle juvenile delinquents. There was an old program up in Boonville, which is where all the kids went, and that was just a miserable failure. Boonville was closed in the mid-90s, I think, early 90s, and Division of Youth Services took over. Division of Youth Services has multiple facilities, I'll say, statewide. But when you refer a child to Division of Youth Services, what's interesting is you as the judge don't pick where the child gets placed. So if I say, Richard, I'm going to sentence you to Division of Youth Services, they pick where you go. They prefer that I not give you a limited sentence. I mean, a term limited, meaning that I don't specify how long you have to be at whatever facility they want you to go. So it's really, they control how long and where. What is also interesting is that if I sentence a child to Division of Youth Services, they are out at age 18. So if they're 16 and they've stolen your car and they're adjudicated delinquent and they're then sent to the Division of Services, they're back on the street in 2 years.
Yeah, but what if, Tom, or Judge Frawley, excuse me, what if they haven't been rehabilitated? What if they continue to be a danger to steal another car? How is the community protected?
That's one of the problems, in my opinion, is that I do not have the ability to order the Division of Services to keep the child till 21. The division has the right to come to me and say they would like to keep him for additional period. I can then say yay or nay. I don't remember being asked during my 5 years to do that. And although I might have been, I should say just parenthetically, without trying to make this more complicated, I was the only actual judge. The other people that were in the building with me were commissioners, and I had to be the one that signed off on their orders. So therefore, any request by the division would have come to me, even if I hadn't been the trial judge.
Do commissioners, are they trained in the law, have a law degree,
Absolutely.
licensed?
They have everything, everything I have, other than that they are appointed by the circuit, by circuit judges, as opposed to by the governor.
And they're paid a
and they do
full-time
not
salary?
stand for election. They stand for retention, quote unquote, with the judges, but not for election or retention with the populace.
I'm going to back up slightly and ask this. Suppose one of the members of our church hearing your presentation here today says, oh, this is interesting. I'd like to go down to juvenile court and watch the juvenile judge in person conduct hearings and things. Is that possible?
I think so. There was part of the specifics I'm going to be a little vague on, since I haven't had to deal with them for 15 years. But it used to be that the only things that were open were A and B felonies, which would be the really serious robberies and murders and things like that. But my understanding is there is an open, the Supreme Court modified the open hearings rule 10, 15, 20 some odd years ago, and I think the juvenile court hearings are open. I always viewed them as open. My view was transparency is important, both for the community and the family, and the press is a little different, but they could certainly go down and find, certainly the city is, the juvenile officer down there, his name's Catherine Herman, is one of the most efficient, skilled people I've ever worked, I'll say with. I don't, it might even be I worked for her. She was incredible. And certainly if they call juvenile court in the city and ask for Catherine, hopefully she won't come after me, but they can call in there and she can tell them whether they can come in and watch. But it's not the most interesting thing, I will say, and also you think the case is going to happen, as with all court proceedings. You get down there, the young man or young woman pled guilty, or the case got moved, or was continued because a witness wasn't available. So there's all of the comings and goings that go with the court system. They happen in juvenile just like they do in adult court.
So in 1971, when I went to juvenile court to testify against the armed robber, could I have brought my mom along?
I think so. You
I
probably.
wish I would have known
In
that.
your case, Richard, it probably would have been good.
I agree, I would agree. You're absolutely right. Now, on the, I know we'll get into this in our next session, but in terms of confidentiality with respect to the other side of the juvenile court, neglect and care and things of that nature, is there confidentiality under those circumstances?
I think there is. I was a little less open with that. The problem becomes of care and protection is usually the public generally isn't, I don't want to say they aren't interested, that's unfair to the public, but in terms of a specific child, you don't even know what's happening unless it's somebody in your family. So most of the people that are there are family connected, or the foster parent or parents, other siblings of the child, or the kids of the adoptive family. So it's generally, it's confidential, largely because the courtrooms are very small. The room we're sitting here in at the church is probably, my courtroom was probably half the size. You could probably put 2 of my courtrooms in this room. And so it's not interesting, and I say that not to demean the young men and women who are the subject of the matter, but it's really driven by the tragedy of the family setting.
Understood. Now, let's focus on those heavy-duty crimes and how that differs a little bit from the crimes, which are still serious, as you said, but not as serious as murder, rape, armed robbery, and those sorts of things. What happens under those circumstances?
There's a statute wherein certain level cases, certain types of cases can be certified to adult court. And what that means is that the juvenile office can ask for the case to be sent to up to adult court, and they would file a motion to have, it's called a motion to dismiss, which is kind of a weird concept, but the motion to dismiss is filed, and in essence it says, Judge, we think this alleged crime is so serious that the young man or young woman should be tried in adult court, and consequently this matter should be dismissed and to be refiled in adult court. And it's called a certification hearing. So what's interesting, and is a big bone of contention, and maybe in some respects rightly so, is that when I hear that case, I am to assume the young person committed the offense with which he or she is charged. So we don't try the underlying facts of what the child did or didn't do, and whether he or she is guilty, if you will, or should be adjudicated to have committed the offense. That's to be assumed. So all of the factors, if you will, that are looked at are rehabilitative. And what are the chances this young man or this young woman can be rehabilitated in the juvenile system? Well, obviously, from my perspective, it always was, the closer the child is to the age of 18, the more likely it is he or she is not rehabilitatable in the adult system because time's too short. But you look at number of prior referrals, you look at is this a victimless crime, quote unquote? In other words, is it a multiple drug offenses? Because one of the areas in which certification can be requested is 3 prior felonies, and so you've got factors such as that. And by rehabilitation, and is really to me the most critical factor. Once the child, if dismissal is granted, the child is then in front of the circuit attorney in the city or the prosecuting attorney in all the other counties, and he or she decides whether to issue, and they may not. Generally, it was always my belief that the lawyer for the juvenile officer and the lawyer for the circuit attorney or prosecutor had some communication, and therefore the juvenile officer's attorney knew going in, whether it would or wouldn't be issued by the prosecutor. So once it goes to adult court, you have multiple issues in that the youth is not, and this is federal law, is not housable with adults. And yet you don't want him housed with the juveniles, so you've got to find a place for him. He's now subject to bond or bail. There were cases that I had in front of me where the lawyer for the juvenile requested the case be dismissed and sent to adult court because the lawyer knew that once he got to adult court, he would be put out on bond right away. And therefore he, in terms of a pretrial setting, would be on the streets rather than in a juvenile detention facility. San Luis City has its own detention facility. The kids are at school. They have school. San Luis Public School has a contract with juvenile. San Luis County has its own detention facility. Others, St. Charles does. But outlying areas like Troy and Warren do not. Troy houses its children in St. Charles, I believe, as does Warren, I believe. But they have to find places for it. So they then have to pay, if they use St. Charles, they have to pay a per diem rate. So there's an expense to that. Obviously, if you have your own detention facility, you've figured out your cost going in, and whether you've got 2 kids or 4 kids, cost is roughly the same. Now you go to 10 kids versus 2, obviously. But yeah, so they can end up in adult court, and there's some nuances to that, which we can talk about if you want.
Well, let me just back up and say, or ask a question. Do you mean to say that a lawyer representing a juvenile in a certification process would want the juvenile to be certified and be tried as an adult with all the consequences associated with that?
Could, depending on the crime. Obviously, it's a balancing act. But the piece that and you see this in adult court, the first thing these people, young men or young women, whatever age they are, think about is getting out of jail. They don't think past 2 minutes from now. And so if you as your lawyer goes in and say to this young person who's, let's say, 17 or 16 and a half, if you go down to adult court because of the nature of your offense, they will let you out. I can get you out of your own recognizance for minimal bond right away. That's a no-brainer for these kids. They don't think past the fact that now I'm in adult court and I don't know what's going to happen to me. On the other hand, depending on the offense, I think there's a certain level of certainty that the young man or young woman, even though in adult court, will get some form of probation. And as a result, although they'll have an adult conviction potentially, if they walk down probation, they will have gotten, quote unquote, the best of both worlds, and that they weren't sitting in the juvenile facility and they were put on probation just as they would have in the juvenile court. I guess the other problem could be juvenile case would end at 18, probation could be 5 years, which would be from, if it's 16, up till 21.
Let me ask you this. At the time of sentencing in adult court for a conviction of a felony, I know that the court, in looking at the sentence, can take into account prior adult offenses, felony cases. What sort of rights does a sentencing judge have with respect to delinquent convictions in terms of prior offenses?
At the adult level?
At the adult level. Would the sentencing judge know about the juvenile record?
I don't remember having any juvenile records. I mean, I did criminal from 09 to 17. I don't remember all the people I sentenced. I don't remember having any juvenile records. In the city, and maybe it's a sad comment, but I would say most of the folks that come in front of me either have minimal to no record, or they've got a long enough adult record. You don't need the juvenile records, unfortunately.
Yeah, that is unfortunate. In your time as a juvenile, you obviously had lawyers who were part of the public defender office. Did you see many paying lawyers, as they would be called, lawyers in the private practice?
I saw some, not many. The one I remember was a certification. I had a private lawyer. I'm sure I did in some, and I had in St. Charles I had Al Watkins, which was who.
Who was he?
Al Watkins is the lawyer who was involved in the Greitens case, Governor Greitens, when the $200,000, more or less, was delivered. And he is currently the lawyer representing the QAnon, the fellow that was wearing the horns that was in the Capitol. And Al's a wonderfully good lawyer, really good lawyer, and a really good guy. But Al has a very good vocabulary, which required me to spend a fair amount of time trying to figure out what the words were, how they connected. But so I had Al in front of me in St. Charles on a I remember it as being a possession of some case of some form of drugs. I had Nick Zotos in front of me in the city. Nick did on a certification. I know I had others, but those are the two that come to mind.
And Mr. Watkins is a fierce advocate. He's a very, very good lawyer.
Good lawyer, really.
And he's clever and quite glib and expressive, which I say in a complimentary way.
Oh yeah, no.
That must have been a bit fun.
It was. You don't want to. It's sort of a weird thing to say when you're sitting up there and dealing with a young man or young woman in delinquency, but when you have interesting lawyers, whether it's on either side or both sides of a trial, they make you sit up there and really think, because you're wondering what the next curveball is that they're going to throw you. It's very it's more challenging, more stimulating, and but the public defenders did a very good job. And the issue that is now nationally with all of the certification things that we're talking about is the juvenile brain in development. And
tell us about that.
Well, the theory is, and I think it's largely correct, is that the juvenile brain isn't fully developed at age 17 or 18. And certainly not below that. And so the question then becomes, how can we as a system punish a young person who does something, as heinous as it may be, when their brain isn't fully developed? Well, and it's used, that argument is, at least when I was in the bench in juvenile, was almost used exclusively in certifications to keep the kid from going to adult court.
Were you persuaded in some instances by that
No.
evidence?
No, not on that issue. And maybe I was raised in a pretty strict household, but my parents always said, "Did you know what you did was wrong? If you know the difference between right and wrong, it seems to me that's the bellwether." But the other part of it is you're juggling this brain development piece with the fact that at 18, the Division of Youth Services loses jurisdiction over the child. And so 13-year-old, you didn't have to convince me much to leave that child in juvenile. He's got 5 years to get it together. 16 was a whole separate question. That was a lot harder because you've got a year, maybe, till they're a year and a half, till they're 18. There's a law passed a year ago in Missouri now to increase juvenile jurisdiction to age 18. So in the past, if you commit an offense on the 364th day of your 16th year, you're automatically in juvenile, subject to certification. If you commit an offense on day 1 of your 17th year, you're automatically in adult court. So depending on a two-day lapse, you could be in a juvenile or adult court. So there's been a movement, and it was then adopted legislatively in Missouri, that we're going to increase the age of juvenile court to age 18. So now that 2-day lapse is between 364th day of your 17th year to the first day of your 18th year. The problem is it wasn't funded. Therefore, there's a good article in the Post-Dispatch a couple weeks ago addressing all this. There's a real question about whether the law is in effect. The judiciary's asked for $13 billion, I think, to fund this increased age, because you now keep them for an additional year in your juvenile facilities. Division of Youth Services now has an additional year of these kids to have to figure out how to monitor them. You may have to hire additional workers or whatever, because you pick up more cases, et cetera. So it's some of the circuits, as I understand, are implementing the statute, notwithstanding the lack of funding. Most of the circuits statewide are not implementing the statute because of lack of funding. So that's another issue that is something the folks can keep an eye on.
With the brain development defense, does that issue tend to arise especially in death penalty cases? Is that where it becomes most?
You can't, well, there's no death penalty for the juveniles.
Okay, well that's
Okay.
a good thing.
And I don't think, my recollection is now the Supreme Court has said you can't give them life without parole. So what you've got is, for me, and from the cases I saw, and this is a whole, and again, I say I've been going 15 years, so this is a whole evolution of, it's always, and you remember from your days in trial practice with, not when we were in school, but in real life, is that once a theory is developed by a lawyer or a group of lawyers, and it seems to be working, everybody latches onto it because it seems to be the thing that works. And so what you've got basically is it's really focused on keeping the kid who's charged with a heinous crime in juvenile court. And it's used almost only for that. And the reason it has, to me anyway, minimal impact is that I'm to presume the young person committed the offense with which he is charged. So there's no argument allowed by statute on, well, it wasn't as bad as the police reported. It isn't as bad as the victim says it was. It isn't, they weren't as at risk as the victim thinks they were. So I don't get any of that. The only thing I get is, was there a weapon involved? That's the only piece, that one of the factors I can look at, is whether a weapon was or wasn't part of the offense. So you really, to me, as I said a minute ago, I'm kind of a, did the young person know the difference between right and wrong? So if you're going to tell me by way of brain development, they were so undeveloped, they didn't understand right from wrong, that's, I think, fine. But telling me that 15-year-olds don't think like 21-year-olds, I agree. The problem, I think, frankly, on the practical level is in a society these kids grow up in with all these video games, is they kill people all the time in the video game, and they push a button, everybody pops back up. I don't know that some of these kids can translate that isn't real life. You shoot them with a gun in real life, they go down, they don't get back up. You don't push a button. I never had a kid in front of me that I could have that kind of discussion, but I've always wondered how much of they're playing video games that involve stealing cars and violence has impacted their thought process, and that video games and real life are not different, and therefore these people will come back up.
I tend to agree with you. That could very well be a problem.
Yeah. So
with respect to age, being a trial lawyer, in some rare cases, does it become a contested issue as to whether a child is really a juvenile or should be prosecuted as an adult? Is there any debate about that because records don't exist?
I never had one where the records didn't exist.
Okay.
So it was never an issue in front of me. I guess it could be. You got all these, I suppose it could be. You've got, using some of the, as an example, some of these ball players from Latin America. Nobody really knows when they were born. I think there's a debate, isn't there, about Albert Pujols, how old
Yes.
he really is. Not that he was ever in juvenile court, but I suppose it could be an issue. I never had it.
Of course, Albert was mature beyond his years,
Absolutely.
I think, regardless
Absolutely.
of his age.
But I think the more, I guess the more young people that come across our borders, it could become, I never had that issue. And the city was fairly diverse when I was there. It's probably more diverse now. But I had some Bosnian youth, some African American youth, Caucasian youth. I'm sure I had a few Latinos, but it was still predominantly African American, and it was almost way predominantly non-white in the city, and I would think of the non-white predominantly African American.
So you were in juvenile court for 5 years.
I did.
How long were you on the bench total? Adult
November of '91 until February of '17. So I think that's 26 years, or 25 and a half, something like that.
So you, during your career as a judge, you handled civil cases, criminal cases for adults. Your juvenile court experience, divorces, and equity, as they call it. How does your experience as a juvenile judge and your memories of it compare with your other experience as a judge? Special, super challenging, interesting, heartbreaking, I hated every minute? How would you characterize it?
You know, I really thought, folks, he wasn't going to ask me. He sort of told me the question he was going to ask me, and he wasn't going to throw me one. And here, okay, this is one I'm not prepared for. I can tell you, I just stayed in. I had no interest when I was in private practice in juvenile law. It was something I had no interest in, and I don't know exactly why. I had experience in it, in that my wife and I were foster parents, so we had kids in our home that were foster kids. But in the late '90s, when and I'm on the bench for a while, we had a young man who was in our home who had a juvenile court proceeding. Wasn't a delinquency case. I was told I couldn't go in the hearing. I was a judge. There was a kid living in my home, and the judge wouldn't let me in. And that's what told me, from my perspective, I needed to go to juvenile. And while I was there, I loved every minute of it. I had great staff, from the best people in the world, some of whom I stay in touch with. I go back periodically, and I'm treated well, better than I deserve, by the people that were there then and still are. And I would have stayed my whole career, which would have been a mistake for multiple reasons. I would have never left. But we rotate out, and so it was my turn to leave. Or maybe the reverse, somebody else's turn to come in. What did we do while we were there? We did some incredible work, and I say we. It was a unified effort.
What sort of incredible work? Special projects, initiatives?
All kinds of things. And the care and protection side was one of the most significant things we did, and I'll leave that till for the April session. We focused. One of the things that were left out, had been left out a lot of juvenile, was the victim, and still is. Parenthetically, I was appointed by our governor, Governor Parsons, to the state advisory group on juvenile justice, and as a result of that, was fortunate enough to get appointed to and everything in Washington goes by acronyms. So I'm going to say it's the FACT-JJ. You're going to test me on whether I can come up with what those letters are. But I think it's the Federal Advisory Council on Juvenile Justice. I think that's the FACT-JJ. It's a 2-year appointment with potential for second 2 years. I'm starting my second 2 years, so it'll be a 4-year term. And one of the things we are working on in the second year, in the committee I'm on, is victims. And the victims being treated, I don't say fairly, but recognizing that they are part of the system. So one of the things that we did in the 5 years I was there. And part of the reason we got this done, and I'm going to go back to Catherine Herman, whose praises I sing, also the juvenile officer, lawyer Susan Guerra, and the folks working there in terms of the juvenile officers, the deputy juvenile officers, is we tried to make sure that victims were heard and had the opportunity to present sentencing, if you will. We created community boards for lesser offenses so that some of these young people would understand that there is a victim. When you break into somebody's garage and you take their lawnmower, there is a victim. Now, it may not be a big deal, quote unquote, to you in terms of you're taking the lawnmower or to the community as a whole, but it is a big deal to the guy or the gal or the family whose lawnmower is now gone, or when you steal their car, even though you don't trash it, they don't have it, or you steal their hubcaps or whatever it is. And so we got a number of the communities in town to create their own community boards. And so we would have young people who we would have go to them, and that community would assess its own punishment, quote unquote, meaning, you've got to clean up the alley. And the young man, excuse me, or young woman would have maybe come out the other way, the victim would have the right to explain to the kid, well, how this has impacted my family, okay, or my child, or my livelihood. I couldn't get to work. I missed 2 days of work. I'm an hourly employee. I don't think kids appreciate even these lesser level crimes. And so we tried very hard, and I think with some success, we had a number of communities that jumped into this. But the victim is sort of this lost part of the equation in juvenile, and we focused on that. Excuse me. We created a truancy division.
For what purpose, sir?
Truancy is in my opinion, the single most problem in the city, maybe statewide. If you don't have an education, you kind of limited your prospects going forward. Also, if you're not going to school, you're out on the streets somewhere. And some of the problems were simple. Mom and dad, or single mom or single dad, went to work at 6 o'clock. They woke the kid up. Kid was supposed to catch the bus. Well, guess what? Go back to bed. Don't wake up. Or you left the older child in charge of the younger child because you had to go to work. So some of the problems were just the creation of life. And there was nothing, nobody was doing anything wrong. Some of it was the parents weren't educated, didn't see any need to be educated, had really pretty good jobs, and so there was no incentive to the kid to go to school. And so we created some truancy courts, which went into the schools themselves. We picked the high schools, which was probably, it was from my perspective, and looking backwards, we should have gone to the elementary schools. There's a point in time we can debate what that age is, where it's educational neglect versus truancy, where it goes from a parental problem to a kid problem. And I don't know what age that is, but obviously kindergartners more is educational neglect, to a junior high school is more a kid problem. And I think we probably should have focused more on the younger kids when we started. I think that evolution has taken place, and I think what the truancy division is, I think, taking its work down to the lower grades. But it was to try and make contact with the kids, to see if we went to the schools, we could make sure the kids were in school, parents had to come. It had some success. The problem was the multiple of all the various. Mom and dad can't take off of work, understandably. The kid's got his or her own explanations, excuses, on why they couldn't do, or why they didn't do, or why whatever. And so it wasn't the simple task of buying an alarm clock. Sometimes it was, but usually it was a more ingrained problem of trying to have the young man or young woman understand. I'll give you an example, maybe. Law students at Washington U, as I remember, they have back then they had a women's law student. I don't know whether it's now gender-driven or not, but back in the day, for whatever reason, the women had their own group, and they wanted to participate with our kids in detention and with the girls.
Being
And so-
experienced, being
No, why don't you
detained?
come in and have a roundtable discussion about, try to get an education, work on your skills and things, and try and show them that there is a path other than a life of not doing what you're supposed to be doing. And so the law students prepared a whole program, and not a law, but something to talk about. And all the girls in our detention facility wanted to do was talk about nails and hair. So it was clear the bar isn't, for these kids, unfortunately, isn't set as high as you would like the bar to be set. And some of them are, and I will say this more about the girls, I'm talking about the boys and men. And so we also tried to form relationships with the kids in hopes that they could see that me as the judge is not a complete person who's just nothing but authority, and that our other people in the community, like these law students, want to help the girls. Some of the girls were richly bright and incredibly able. I mean, beyond able. And just figuring out how the switch was just so hard. They could have, they were very bright, could talk about multiple things, had interests beyond hair and nails, not to demean that, but as necessarily as the height of where you want to be. And we just couldn't get inside them. So as to the boys, we had basketball games with the juvenile officers and me. So in 2000, I was 53, I think, 47,
Yeah.
53. And then 2005, I was obviously 58. So it was a struggle. But St. Louis U let us use their old gym, the West Pine gym. We'd go down there periodically and have games. And it was a way for the juvenile officers and me to try and forge some relationships. How many kids did we save? I don't know. Did we save any? I don't know. But it was, so we tried to form relationships with the kids, not just as authorities. We tried to include the victim and have the kids recognize that there's a victim. And we tried to deal with some of the status offenses, and most particularly truancy. On that side of the aisle, those are probably the things that we did that I would find to be the most rewarding. But it means some of these kids, it's really, some of them you just wonder how they get it together, how they keep it together day in and day out with all that's going on around them. And you kind of hope that you could figure out a way to help them. I mean, one of the other problems the juvenile system historically has been is that it's been focused on boys, and the girls have always been shortchanged. And so I went to a program early on in my juvenile career, maybe even before that, and the gentleman, lady, whoever it was speaking, kept talking about programs for girls, and the speaker says, just because you paint the room pink doesn't make it a girls program. And I've retained that thought, and we tried to use that. And when we got there, it's just because we put them in the same room with the boys and we painted pink doesn't mean that program is going to help the girls. And so we tried to develop, and that's what I said with the Washington U law students and some other things we did with the young women. We tried to come up with things that were directed at the girls and the issues they have. And so, but it was tough stuff. It's tough sledding.
I bet.
For everybody.
Kevin, did you have any questions with respect to this particular segment of Judge Frawley's presentation?
A couple things. One, I wondered about, you talked about the whole person playing basketball, and was there ever any connection with faith communities?
Yes. Our efforts were with the city, because we were city court, with the city, it was more driven by the African American churches, because most of our youth were African American, and our efforts were not as successful as we would have hoped.
I'm going to just get off the juvenile court subject for just a minute and ask you something about how you've observed that the state courts have been impacted by COVID. Do you have a perspective on that, Tom?
Well, I've been retired since 2017, and so the COVID obviously happened post my retirement. So my observations are as a judge, but also not much different, from the same perspective as all of you have. I think it's, first of all, there haven't been, outstate's different than the metropolitan area. St. Charles has had jury trials. There's some other counties in the state have had jury trials. But St. Louis City has not since COVID hit, so it's been a year. St. Louis County, I don't believe, has either, because the number of, this Chief Justice has, I think there's 4 phases of where each of the courts are, and it depends on when's the last COVID outbreak. And because the number of employees St. Louis City and St. Louis County have, there's a greater chance that you're going to have an employee with a COVID issue. Also, because of the fact that the clerks are underpaid, most of them work secondary, the deputies too. So they're now exposed twice, one in their primary job at the courthouse and 2 in whatever other job they have. So there have been no jury trials in the city or the county. I'm not sure if Kansas City has. So from a criminal standpoint, unless you're willing to plead guilty, your case, or you're willing to do a bench trial, you are just sitting in jail unless you may bond. Most lawyers representing the defendants who are charged with something significant don't want their case to be a bench trial. The guys don't want to plead, and you don't want to do a jury trial by Zoom. So they're just sitting there. So it's a real problem. Divorces, some are being done by Zoom. I've been asked to do some by lawyers on a sort of on a contract basis in person, which I've done, and we do it in a room maybe about the size of your room here in the church, where we are all socially distanced and everybody wears masks except the witness and the lawyer, and we make sure they're separated from everybody else. So there's not a lot moving there, because part of the reason I think lawyers don't like Zoom trials too much is, first of all, documents can be shared, but it's a huge pain. You get 85 slides up on your screen, and you got to move back and forth. Secondly, most of the Zoom things I've done, you don't see all the way down to the table, and I've always wondered, in some cases, whether there's a script, whether the answers are underneath that they're reading from, or whether the witness and the lawyer have 1 is for yes, 2 is for no. So I think there's a lot of lawyers that are skeptical of Zoom or WebEx or whatever you're using. So I think the system's largely stagnant. And I'm sure these folks have read about the incident happened at the city jail, where a lot of the inmates got a little violent over the weekend, and I think a lot of it's that nothing's moving, and they're frustrated, and that's not to justify what they did, but I get their frustration. But so it's been a significant impact.
I see our time is about up. Kevin, anything else for now?
I have a lot of questions, but better not.
All right.
So let me say also, folks, one of the things, and if you've never seen the way this is set up, if you don't think, I'm not looking at the picture because I'm looking straight ahead, and that's why I'm looking out the window. So if it looks like I'm looking at something other than Kevin in and the camera. That's why.
Well, this was good stuff, my friend, and I knew it would be. Ladies and gentlemen, we're grateful, Tom, for your presentation. And also, I single out your service as a juvenile judge, because my perception from what you said is it might have been the most important job you had and function you had as a judge. And I think I said this the last time, but Tom is the energizer. He will not sit in his chambers at the courthouse and wait for something to happen. If his docket is cleared for the week, he'll raise his hand and volunteer, as he's talked about, to go out to Warren County and St. Charles County, and he will travel. And that is the exception rather than the rule. So we thank you for your service. Tom, we thank you for your wisdom and time today. I do want to just put in a quick plug, if I may, for our upcoming programs. Next week, Jan Worley, the religion instructor from the St. Louis Community College, will present 2 hours live about forgiveness. So he's got a lot to say, but he also wants to hear from our members. And then after that, on March 14th, John Russell will give us an update on COVID. Then on March 28th, Dr. Bill Owens on the history of anesthesiology. And then, that's March 28th. John Russell is going to talk on February 28th on a timely subject, which is the Black Lives Matter controversy. And he'll be answering one of the questions which always comes to people's minds: why aren't we worrying about everyone's lives? Why is it just Black Lives Matter? So that'll be on February 21st, I think it is. And then after that, on first part of March 7th, we'll have Dan Livengood talking about climate change and his experience working for Bill Gates. And then on March 28th, we have Bill Owens. And then John Russell on March 14th. Sorry, I'm hopping around on this. And then, Tom, will you be able to come back in April and make a presentation?
Absolutely.
Very good. We
Happy
look
to do it.
forward to that. Thank you, everyone. Have a good day. Stay well.